Hello, this is Matt on the Moon Lambeau channel. A few days or so ago, the SEC filed a supplemental document to the court, and they were arguing that a recent development in a separate court case, SEC versus Fife, I believe is the actual name of that court case, or something to that effect. They were arguing that the SEC won on the fair notice defense in that case. And they were using this as supplemental information for the court in an attempt to persuade the court to deny Ripple's defense, specifically the fair notice defense, so that they couldn't even argue it in court. Now, today, and by the way, I'll mention this too for those of you that missed it, I made a video where I did my best to tear the damn concept to shreds, and what I was focusing on in that video a few days back was just how different these cases are. And so, to be clear, what I was arguing was on the topic of whether or not Ripple did receive fair notice, and a couple of major differences from one case to the next, which are very clear, especially when you're talking about completely different asset classes here. And so that's what I was focusing on here. But Ripple filed a legal document today in response to that. And I want to be clear at the outset here, like, this legal filing from Ripple's legal team argues why Ripple should be able to proceed with its fair notice defense, okay? Ripple is not making specific arguments in this legal filing regarding the reasons that they believe they did not receive fair notice from the SEC. So, going to be clear, that's what I was talking about in my last video, the reasons that Ripple did not receive fair notice. And I was also talking about how one case is very different from the next, and I talked about that as well. And so, but again, so that is a very different argument, and one that they'd like to make during the trial, one that Ripple's legal team would like to make during the trial, again, regarding the specifics of why Ripple did not have fair notice from the SEC. But you see, they can only make that argument during the trial if the judge does not throw out Ripple's fair notice defense. So again, what Ripple's legal team is talking about in this most recent legal filing, they're just arguing, hey, we should be able to talk about this during the court case. We should be able to use this as defense and really flesh out our argument. That's really all that they're getting at here. Now, I've also got comments from attorney Jeremy Hogan and also attorney John Deaton. So plenty to talk about here, but I do want to be clear at the outset, I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto topics, but just as a hobby and just for fun. And so I want to share this, just a short few comments from attorney Jeremy Hogan first to kick this off, and then I am going to get into the Ripple's legal filing from today. But here's something that Jeremy Hogan wrote on Ripple's fair notice defense, because he does believe that that the fair notice defense will survive the SEC's attack. That is what he believes. And so he wrote the following: why Ripple's fair notice defense survives the SEC's motion to strike. In the Kik Interactive case, the court ruled against Kik on the fair notice defense as seen in the order below, which distinguished the Upton case. Let me pause right here. I've talked about the Kik Interactive case. The Upton case has also come out in videos. I'm going to have to assume for the purposes of this video that you have at least some sort of vague understanding of them, or like at least get the reference, because otherwise I could splinter off into way too many paths and thought processes that would take this video far outside the scope of what I intend for it to be. So I'm sorry if it looks like I'm glossing over this, but I can't talk about every single detail to that degree in every single video, or else I'll just have like 3-hour-long videos on every single topic, and it'd get really repetitive. So I'm sorry if you don't know what those are, but I got to move forward here. Then Jeremy Hogan wrote, however, the adverse ruling was at summary judgment and not at a motion to strike. And so, to be clear, what we're talking about here when it's talking about summary judgment, that's where the final determination is made in terms of which side is right and which side is wrong. That's not where we're at with the Ripple case. Right now we're talking about a motion to strike. Now, both have to do with the fair notice defense, yes, but they're to be treated in different ways as a result of this, and you'll see why. Here's additionally what attorney Jeremy Hogan wrote. For the Ripple court to distinguish the Upton case, it would have to refer to things outside of the lawsuit. For example, whether the SEC was inconsistent in enforcement across the industry for years, or whether the statute authorizes discriminatory enforcement. Reference to outside evidence is not proper in a motion to strike. Analysis should be limited to whether Ripple pled the defense properly. And so again, this goes back to what I was stating at the outset of the video. We're just talking about whether Ripple's legal team in court during trial, whether or not they should be allowed to flesh out their case, arguing that the SEC did not provide fair notice to them. That's what we're talking about, whether or not they should be allowed to argue it. And as a result of it, that's why Jeremy Hogan here is saying that you don't need to talk about these other factors that he cited right here. And then he wrote, therefore, I believe the court should not strike the fair notice defense. Whether the fair notice defense wins at summary judgment, a 100% different analysis. Yeah, exactly. And that's correct. So even if Ripple wins on the fair notice defense and the SEC's attempt to strike it, if the SEC fails there and they're, Ripple's allowed to proceed, that doesn't mean the court, of course, that Ripple wins the case because of that. What would mean a win for them is if the court finds, as I've been saying on this channel, if the court finds that Ripple did not have fair notice, that would be a win, because you can't not provide a fair notice for anybody operating in the space and then retroactively come back and say, oh yeah, by the way, you were doing this wrong the whole time. You can't do that as a matter of law, which is good. You wouldn't want that. And so then there was this from attorney James K. Filan, who is also a member of the XRP community, and this is the gentleman who very regularly is sharing all of the legal filings from this court case with everybody on Twitter, which is incredibly awesome. This guy is a rock star. Well, all of the attorneys in the XRP community that are participating in any way, they're all pretty damn incredible. Let's be real here. And so he shared this document, and he wrote, Ripple has filed its response to the SEC's notice of supplemental authority regarding the SEC's motion to strike the fair notice defense, which reads as follows. And this is from Ripple's legal team. Dear Judge Torres, we write on behalf of defendant Ripple Labs to respond to the SEC's letter notifying the court of the out-of-circuit decision in SEC v. Fife. Fife does not support the SEC's motion to strike Ripple's affirmative defense that it lacked adequate notice that XRP was an investment contract. The court in Fife determined only that it would not, at the pleading stage, dismiss the SEC's adequately pleaded complaint on the basis of the defendant's due process challenge. The question before this court arises in a completely different procedural posture: whether Ripple's answer plausibly sets forth a cognizable legal theory for its affirmative defense, such that it should be permitted to develop evidence and present the defense on a more complete record. That is clearly the case here. Ripple's fair notice defense is firmly rooted in binding Second Circuit precedent. Unlike in Fife, Ripple is not relying on its fair notice defense to preclude the SEC from taking discovery and proceeding to merits adjudication. Indeed, factual discovery is now complete. Ripple is simply asking that it not be precluded from presenting its legally cognizable defense on a full record. Pause right there. So that's what we're talking about. And this is what Ripple is arguing here in this case. That's why, to be clear, I stated this at the outset of the video so that there's no confusion here. Ripple's making the argument that they should be able to make the argument that they didn't receive fair notice. That's effectively it. Right here. They're not citing the reasons, because it would not be appropriate in this letter. They're not citing the reasons that they didn't have fair notice, though. And then the Ripple's attorney continues here. The law in this circuit is clear that an affirmative defense to a claim may only be struck where there is no question of law which might allow the defense to succeed. So there you go. And so right there, I mean, it's pretty damn clear that this isn't exactly open and shut, which is why that's a crucial piece of information. Again, they wrote, the law in this circuit is clear that an affirmative defense to a claim may only be struck where there is no question of law which might allow the defense to succeed. And so it's definitely not that. There's evidence that has already been cited. Don't get me wrong. Like Ripple has talked about some reasons why they don't believe that they received fair notice from the SEC. And so they're just saying they want to be able to argue further. It is not so open and shut that the court should not allow Ripple to bring this up as a defense in the court case, which is why Jeremy Hogan seemed to say rather confidently that he thinks that Ripple's fair notice defense survives this. It survives, he thinks it will, the SEC's attempt to strike the motion. And then they wrote... here we go. Under that appropriately demanding standard, any disputed substantial issue of law requires denial of such a motion. Even if Fife, an out-of-circuit decision that is not binding on this court, supported the SEC's position, and it does not, that still would do no more than create a disputed or substantial issue of law requiring denial of the SEC's motion to strike. And this was signed by attorney Michael Kellogg on behalf of Ripple. And so Jeremy Hogan then shared that document from earlier today and wrote the following. Ripple's argument is clean, concise, and correct. The Fife case was talking about making orange juice, but the Ripple case is just talking about whether the oranges can even be picked off the tree. That's different procedural posture in lawyer talk. And then attorney John Deaton, in response to that initial few comments that I shared from attorney Jeremy Hogan before reading Ripple's most recent legal filing, John Deaton actually shared that from Jeremy Hogan and wrote the following. XRP holders should read this brief but accurate analysis because I've noticed that some mistakenly believe if the judge decides the motion to strike in Ripple's favor, that means Ripple wins the case. It does not. It only means Ripple can argue a lack of fair notice as a defense. And again, that's what I've been saying throughout this video multiple times, just hammer the point home, and that's absolutely true. It's a slam dunk for Ripple if the court finds that Ripple didn't have fair notice, but the topic at hand is whether or not they should even be able to argue whether or not they had fair notice, which is a separate legal issue. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.